members. Today we will be doing probate and administration, 23rd April 2025 series, and then we'll be jumping to other sessions. So quickly, question 1 reads as follows: that on 20th February 2024, Mr. Kwaheri, while taking a stroll in his expansive farm, overheard a heated discussion between two of his sons, James and John, who were supposedly feeling frustrated that their father, whom they despairingly referred to as that old goat, had taken life forever without dying so that they could inherit part of his wealth. Kwaheri felt very pained and cried bitterly over his son's level of disrespect towards him. He then swore that the two sons would never receive any share of his property, even if he predeceased them. Thereafter, he rushed home, and despite the searing pain in his joints arising from the effects of the advanced rheumatoid arthritis, he wrote a will which was witnessed by two of his cousins, Mzee Munyiheri and Mzee Kombo. Through the will, Kwaheri distributed his property to all his family members except the two sons, James and John, as well as his daughter Amina. For Amina, her dad was always paranoid with her in the belief that she had wanted to kill him. Kwaheri's paranoia arose some few years earlier when he had been taken ill and got admitted to Tenda Wema nursing home in Malindi. During the admission, Amina often stepped in to relieve her elderly mother in taking care of their dad. One afternoon, as she struggled to turn her dad and make him lie in a more comfortable position, Dad woke up from his sleep and started screaming in the mistaken belief that Amina had been strangling him. Since then, he had always been very suspicious around Amina because he believed that she never meant well for him. One evening, Mr. Kwaheri had a bitter disagreement with one of his wives, Jane. He felt that lately, Jane had become too disrespectful to him. As a result, he felt very strongly that she did not deserve to inherit his property. He then went into the safe and picked a copy of the will and used a pen to cross out all references to Jane as well as all bequests he had made to her. Thereafter, he also crossed out his signature, but the writing still remained readable. He followed up his actions by trashing the will into the dustbin, from where it was later retrieved by his wife, Jane, who kept it back in the safe. That night, Mzee Kwaheri died peacefully in his sleep. Based on the above facts and relying on relevant law in decided cases: 1. Discuss the legal status of Kwaheri's will, 10 marks. B. Evaluate Amina's claim to her late father's estate, 5 marks. After his death, it later emerged that on 20th February 2024, Kwaheri had acquired some 20 acres of land which he had intended to donate to Mji wa Furaha Children's Home. As a result, he left it out of the list of his property which was distributed through the will. However, owing to the failing health, he failed to follow through with the intended donation, and by the time of his death, the same had not been passed to the children's home. Distinguish the process of administration of this piece of land vis-a-vis the rest of Kwaheri's estate. 5 marks. So as a recap, I believe now the factual matrix are not that complex because we are involving only 3 beneficiaries. We have the 2 sons and Amina, all of whom have been inherited. One from the conduct of James and John, from referring to the old man that as and that old goat that has refused to die, while Amina, the Mzee thought that Amina is going to kill him after he had woken up. Then we have he's trying to destroy a will, then it is later found, and the circumstances is that he is using a pen to cross all references to Jane, and then she is also crossing out his signature, but the writings remain readable, and he thrashes this will into the dustbin, from where it is still recovered by his wife Jane and keeps it back to the safe. And on that night, Mzee Kwaheri died peacefully. Now, what is the legal status of Kwaheri's will in your view? Is this will valid? Is it existing?
We are looking at the revocation of wills. and we have various ways of revoking, and there is the express revocation, and there is that implied revocation, and this is what we are looking at. And where we have revocation by destruction, it has to be total destruction. So the fact that he closed out but it was retrievable, then that does not amount to total destruction of the will, because it means that the will could be deconstructed back. Yeah. Because it was readable, you only crossed the lines. No other writing, it was readable. Yeah.
Thank you. Mr. Chedik, any other suggestion for you to score the 10 marks?
Okay, thank you. Let me first read the question because I have questions.
Oh, so you'll have to take time to read the question. Okay, so maybe due to time, you will have to catch up with us as we look at the marking scheme to see whether this will is valid or not. So the validity of the will turns on testamentary capacity, due execution, alterations, and alleged revocation. So point number 1, you list it as first testamentary capacity. So under section 5.1 of the Law of Succession Act, any person of sound mind who is not a minor may dispose of their free property by will. Section 5.3 presumes that a testator is of sound mind unless at the time of execution, illness or another cause rendered him incapable of understanding what he was doing. Under section 5.4, the person alleging incapacity bears the initial burden of proof. So the common law test in Banks versus Goodfellow 1870, applied in Kenyan succession cases, requires the testator to understand 1. The nature and effect of making a will, the extent of the property being disposed of, the person who might reasonably expect to benefit, and the manner in which the estate is being distributed. In Estate of J&K deceased 2022, the court reaffirmed both the presumption of capacity and this test. So Kwahiris, rheumatoid arthritis, and physical pain do not, without more, establish mental incapacity. He was sufficiently lucid to identify his assets and beneficiaries and deliberately excluded James and John. The facts therefore support capacity notwithstanding his age or physical illness. So that is one ground of testing the validity of a will. You test under testamentary capacity. You test using the landmark case of Banks versus Goodfellow, the statutory provisions of section 5.1 on testamentary capacity, and then you link the fact to show his medical condition and physical condition. Then another issue that can also determine the validity is hostility towards James and John. A testator ordinarily has freedom to distribute his free property as he chooses. Kwaheri's anger at James and John after hearing them insult him and anticipate his death does not invalidate the will. An irrational, harsh, or vindictive disposition is not necessarily proof of testamentary incapacity. The exclusion would only affect validity if it resulted from coercion, undue influence, fraud, or a disorder of the mind that poisoned his affection and directly caused the disposition. None is apparently regarding the two sons. They may, however, seek reasonable provision as dependents under Section 26 and 29 of the Act. So the examiner is testing whether you know the grounds that can affect the validity of a will. If the two sons had coerced, or there was undue influence from them, or even fraud or disorder of the mind that have poisoned his affection, that is when his hostility towards James and John will be considered. But here you tell the examiner there is a reasonable provision that James and John we should be in a position to approach the court under Section 26 and 29 of the Act. Then another issue that will still determine the validity of the Act is formal execution and attestation. Under Section 11 of the Succession Act, a written will is valid where the testator signs or affixes his mark, or another person signs in his presence and at his direction, 2. The signature is positioned to show that it was intended to give effect to the will, and the will is attested by at least 2 competent witnesses, each of whom saw the testator sign or acknowledge the signature and signed in his presence. Okay, so take note of this criteria under section 11, that the testator can sign or affix his mark, but he can also delegate to another person, but that person must sign in his presence and at his direction. Then the signature is positioned to show that it was intended to give effect to the will, and look at the minimum requirement of 2 competent witnesses. Now, Kwaheri wrote and signed the will, which was witnessed by Mzee Mwenyeheri and Mzee Kombo. The fact that they were his cousins does not make them incompetent witnesses. Nothing indicates that either cousin was a beneficiary whose gift might be affected under section 13. So if it is a beneficiary who is witnessing, it is the validity of the will that will be affected, not the validity of the will. The extent of his gift is the one that will be affected if they don't provide another set of independent witnesses to also witness the will. So subject to proof that both witnesses attested in the manner required by section 11, the original will was validly executed. So we have tested the validity of the will first using testamentary capacity, that is 1, because the question carries 10 marks. We also tested the validity of the will by checking the hostility towards James and John. We have also tested the same through formal execution and attestation, and we have found that it was properly executed. Now let us check the validity from crossing out references to Jane. The handwritten cancellations are alterations made after the will had been executed. Under section 20 of the Law of Succession Act, an alteration made after execution has no effect unless it is executed and attested in the same manner as a will. Authentication will ordinarily appear in the margin or near the alteration or in a memorandum referring to it. Kwaheri made the cancellations alone. There is no evidence that the alterations were signed and witnessed by 2 competent witnesses. They are therefore ineffective, and the will should generally be read as it stood before the authenticated alterations. Since the original words and gifts to Jane remain readable, they may be proved and given effect. In Francis Mungai Ng'ang'a vs. Anna Wairimu Ng'ethe, 2017, the court affirmed that alterations not properly signed and attested do not satisfy the Law of Succession Act. So believe you me, this point was very hidden. Only few students could have remembered the provisions of section 20 of the Law of Succession Act, where an alteration has been made and execution has already been conducted. Then, unless it is executed and attested in the same manner as a will, that is when it will have effect. So take note of such hidden provisions, because people could have assumed at the end of the day the will is still Mr. Kwaheri's will. Another point to be looking at is whether crossing out his signature revoked the will. So under section 18 of the Law of Succession Act, a written will may be revoked by the following. It can be revoked by another will or codicil declaring an intention to revoke it, or burning, tearing, or otherwise destroying it by the testator or by another person in his presence and at his direction with the intention of revoking it. Okay, so there is an actual act and there is an intention of revoking the same. So revocation by destruction requires both a sufficient physical act of destruction and an intention to revoke. So Kwaheri crossed out his signature and threw the copy into a dustbin, strongly suggesting an intention to revoke or alter the will. However, the words and original signature remained readable. The document was not burned or torn. It was merely discarded and later retrieved, and the facts refer to a copy of the will, not necessarily the executed original. Naona? So the facts imesema a copy of the will. Now, destroying or marking an executed copy ordinarily does not revoke the executed original unless the evidence establishes that the document marked was the operative testamentary instrument and that the statutory method of revocation was satisfied. His unexecuted cancellation of Jane's gift also cannot operate as a valid codicil. Accordingly, the better conclusion is that the attempted alterations and revocations were ineffective, particularly if the executed original will remained intact. The will remains valid in its original form, including Jane's gift. If evidence establishes that the document retrieved was the executed original and that crossing out the signature constituted distraction undertaken with a clear intention to revoke the will, the court may find revocation. On the stated facts, however, the limited physical act and reference to a copy make that conclusion less likely. So, what is the conclusion? The will was prima facie valid executed under Section 11. Kwaheri's physical illness and anger at James and John did not remove testamentary capacity. The later cancellation of Jane's bequest was not properly executed or attested and is ineffective. The attempted revocation is also probably ineffective. So the estate should be administered under the will as originally executed, subject to successful dependency claims. Believe you me, still on the last part, many students could not have reasoned out that this is a copy of the original will. Let us go to the factual matrix so that we can believe with our eyes, where we are told this is the point. Unaona, he then went into the safe and picked a copy of the will and used a pen to cross out all references. We had a webinar with CLE. CLE told us that many students will rush to answer questions without clearly understanding the tricks that have been laid down by the examiner. So one of the tricks is to identify these issues that are emanating when the question requires 10 marks, because there is a reason why the examiner wants you to answer with a 10 marks situation. So you have been told there is a copy of the will. You have not been told it is an original will that is going to be destroyed. You have been told directly that he's doing this in his own capacity, without witnessing, without other witnesses. Okay, we have also been told about the disrespectful conduct to him and vis-a-vis his the testamentary capacity and freedom to make a will. So those are the issues arising. And remember, if you read this fact matrix, it is emanating from a landmark British case law. There is Bank versus Goodfellow, unit testamentary capacity. There is Elijoy something. Okay, I'll confirm, but it is directly from a British case law where the wife found it. It was a cleaner who found the torn wheels. He assembled the parts, then still inserted the wheel and kept it in a safe position. So let us say that the tests are also emanating from the decisions that are listed in the cause outline, because that was a direct cause outline interpretation. Now, evaluate Amina's claim to her late father's estate. So now the examiner is telling you, now let us focus on Amina. Now, is Amina's claim to her late father's estate justified? Because you have been told the will, okay, her name, Jane ndiye alimvuta after the will has been entered into. Who is Amina? Let us go to the factual matrix so that we can identify where Amina is coming from. So you have James and John, first paragraph. And then the first paragraph is just about James and John. Yes, any member?
The second one.
The second paragraph, thank you. So through the will, Kwaheri distributed his property to all his family members except the two sons, James and John, as well as his daughter Amina. For Amina, her dad was always paranoid with her in the belief that she had wanted to kill him. Kwaheri's paranoia arose some few years earlier when he had been taken ill and gotten admitted to Tenda Wema nursing home in Malindi. During the admission, Amina often stepped in to relieve her elderly mother in taking care of their dad. One afternoon, as she struggled to turn her dad and make him lie in a more comfortable position, the dad woke up from his sleep and started screaming in the mistaken belief that Amina had been strangling him. Since then, he had always been very suspicious around Amina because he believed that she never meant well for him. So, and as a result, we are told that she got nothing. Now, evaluate Amina's claim to her late father's estate. 5 marks. What exactly is the examiner trying to look out for?
Okay, on this part, I'll say the dependency. One thing, the part being tested is a reasonable provision, is section 26 and section 29. 26 is for
reasonable provision. So Amina can seek for reasonable provision from the court where you will prove he was one of the dependent. Then in section 29 is in 29 about the distribution of the estate. Section 29A state that section 29A state that the spouses, let's say the wife, the children are entitled because Amina is Amina is a real sijui nitatumia the word real a lot, is a child as in Amina was a daughter to the late Mzee Kwaeli, so he has all the right to inherit from his father's estate. Yeah.
Thank you so much. Any other member? Mr. Chelik, are the facts now clear? Don't want to leave you out.
Yes, it's now clear. I do agree with that.
Okay, thank you. I'm also looking at a webinar that we did on how to draft a reasonable provision document, because the next time the examiner will tell you now to draft the appropriate document that will be taken to court. I'm looking for it. I'm not finding it, but iko kwa YouTube. Unaona sasa? Iko kwa YouTube nimeita. How have I called it? Kuna all applications in probate. Kuna the title is reasonable provision. I've seen it. It's very important because in this session that was the main agenda. Unaona? You have not diluted it. You have directly stated even the grounds that the court will look at. Reasonable provision application 2024 marking scheme. So when we were doing the 2024 paper, we discovered that the examiner wanted the full procedure of a reasonable provision application. So how will you approach court? Which documents will you consider? So the link, I'm pasting the same Pale group. I've pasted the link so that you appreciate, because the session took us 37 minutes. So it is a detailed one. We even made reference to the Law of Succession Act. And also some key areas arising is on objections to will and objections and petition. Okay, there is objection. Nyingine that we need to be keen on. Cross petitions, and anyone who knows what I'm trying to say, what is the procedure for filing an objection? Very important. At what time and how will you approach court when you want to make an objection? Because the next time you will be told, now you are representing on behalf of various beneficiaries who want to make an objection. How will you make an objection? Now let us save our souls by looking at channel grounds for reasonable provision, because we said that session was well detailed for 37 minutes, and it is important we save what you don't know. So the exact procedure for filing an objection. So step number 1 is publication of the petition. Under section 67 of the LSA, no ordinary grant of representation may be made until notice of the application has been published, inviting objections within a period of not less than 30 days. So the notice must be exhibited at the courthouse and published as directed by the court, ordinarily through the Kenya Gazette. So you have seen that for you to do an objection, you are within the 30 days period of objection after gazettement. Okay. Now, step number 2 is notice of objection. Under section 68(1) and rule 17(1), a person objecting to the making of the grant must lodge a notice of objection to making of grant, ordinarily in the prescribed form, within the period specified in the published notice, and the objector should also serve the petitioner or the petitioner's advocate. If the period has expired, the objector should first seek an extension of time under section 68(1) and rule 17, supported by an affidavit explaining the delay and disclosing the intended grounds of objection. So if the examiner tells you this family wants to do an objection, but they are out of time, remember section 68, you first extend, you seek first extension of time, then you lodge the notice of objection. So court notice to file further pleading. So upon lodging the objection, the court must issue the objector with notice under section 68(2), requiring the filing of an answer to the petition and a petition by way of cross application for a grant within the period specified by the court. Now, a notice of objection alone does not ordinarily constitute a complete objection proceeding. So it will be very wrong for you to draft only a notice of objection and tell the examiner, look, this will amount to objecting that proceeding. That is very dangerous, because you are told that you will be required to draft an answer to the petition where you are responding to the petition that has been filed by the petitioner, and not only that, a petition by way of cross application where you are telling now the court, if you don't want that grant to be issued to those people, what do you want? Who do you want us to issue to? That now this is a cross application for a grant. Okay, these are your averments, and now the petitioner will also reply to your cross application because you answered to the petition that he did. Very, very important consideration there. So, answer to petition, exactly what should the answer state? The answer to petition should state the objector's interest in the estate, whether the will's validity is disputed, each ground relied upon, the facts supporting each ground, whether the petitioner's entitlement to probate is disputed, and what is the relief sought. That will be the answer to the petition. Allegations such as fraud, forgery, coercion, or undue influence should be pleaded with particulars. Now, we have responded with an answer to the petition on that ground. Step number 5, how will you draft a cross application? The objector should file a cross application stating the type of grant that he is seeking now, the basis of the objector's entitlement, the persons proposed as administrators where applicable, the beneficiaries and estate assets, and whether the estate should be administered as intestate if the will is invalidated. Okay, so we have seen the two distinctions. The first is to clearly set out the objector's interest in the estate, whether the will's validity is disputed, and each ground being relied upon, because you are countering the original petition that has been filed. And now in the cross application is where you are telling the court, look, I have people that I'm proposing as administrators. These are the beneficiaries, and this is the basis of my objector's entitlement, and I need this kind of a grant. Now, consequences of failure to file those documents. Under section 69(1), where a notice of objection has been lodged but no answer or cross application is filed as required, the court may make the grant in accordance with the original petition. Where both are properly filed, section 69(2) requires the court to determine the dispute, and Kenyan courts have repeatedly treated this procedure as mandatory. You see, there are even case laws supporting the procedure. Step number 7, court's powers before making the grant. Under section 70, the court may, before making a grant, examine the petition or another person on oath, require further evidence, call for evidence concerning the due execution of the will, investigate the petitioner's right to the grant, and take steps necessary to satisfy itself that the grant should properly issue. The objector may therefore ask the court to require production of the original will and to summon the attesting witnesses, the drafting advocate, and any relevant medical or handwriting expert. Now, how will you draft a notice and grounds of objection? This is the preliminary draft. So these are the notice appears alike. Take notice that the name of the objector is this, being the deceased son objects to the making of a grant of probate of the alleged will dated this. The objector's address for service is care of this. The objection is founded on the following grounds. that I'm a spouse and has a direct substantial interest. The document dated this, which is being provided as the deceased last will, was not duly executed in accordance with Section 11. At the time of the alleged execution, the deceased lacked testamentary capacity. The deceased do not know or approve the contents. The alleged will was procured through fraud. The signature was lifted. It is not original. Then that is it. So we have discussed about answer to petition and cross application. That we are praying this for grant of probate be dismissed, the purported will be declared invalid, the deceased be declared to have died intestate, letters of administration intestate be issued to this. Alternatively, reasonable provision be made to the objector, the original will be deposited in court, the testing witness and drafting advocate be summoned, the alleged signature or thumbprint be subject to forensic examination, the estate be preserved pending determination of the dispute, etc. So, Section 29 is not by itself a ground for invalidating a will. It identifies the person who qualifies dependents. A dependent alleging inadequate provision should invoke Section 26 to 29, while a party contesting validity should plead the relevant defects under Section 5, 7, 11, and the applicable evidential principles. So, luckily, we have now known the procedure for lodging an objection. Okay, we have seen the timeline. We can extend notice of objection, we draft with other documents, then the court will determine the matter, because that is a mandatory procedure. Now, let us go back to the question and evaluate Amina's claim to her late father's estate. And the question required 5 marks. So let me share the question so that we appreciate what you are doing. Yes, Mr. Chedwick.
So to get your point right, I think that you should first seek extension of time when you want to file the objection. So, and what provision I want to seek the extension of time? Is it the
Section 68. We saw 68. 1. Let me confirm. The extension of time is to be sought under Section 68(1) and Rule 17 of the P&A rules. But that is for grounds of objection, for objection proceedings. Mr. Arnold?
I understand Rule 17 is all about Rule 17 is all about, let's say, objection, answers, and close application. If I'm correct. Then I'm just asking. So in this question, this is our question. Will you rely on Rule 17? Or will you rely more on Rule 17 on how to file the objection, the answer and close application, and support it with the next Section 26 for provisional, reasonable provision, and Section 29 for the dependent?
I've done that deliberately, because now there is a dilemma at the back of your head, because I've not revealed the marking scheme. Still, that was part of the discussion. Now, you have seen about opposition. Will Amina do an opposition? Will Amina do a reasonable provision? And remember, we saw in another question that you cannot do a reasonable provision where a grant has been confirmed. We saw that provision directly. Even Mr. Martin can confirm. Can you bring a reasonable provision where a grant has been confirmed? No. First, you need to revoke that grant, then you do the reasonable provision.
Yeah, first you have to file for revocation. After filing for revocation, the revocation of the will, then even to revocate the will, lazima file those grounds that you are supposed, you need, as in you are eligible for reasonable provision, so that the will can be revoked, if I'm right. Then after proving that the will be revoked, then kutoka hapo ndo ndo sasa you bring up that section 26 ndo uko included by the discretion of the court, and then section 29 proving that you are dependent, because ukuwa mtoto wa mtu hata kama mlikuwa mmekosana, you are supposed to benefit from the estate of from the estate.
Thank you, Mr. Arnold. It is important we check on the grounds for revocation and see, direct from section 76, a grant of representation, whether or not confirmed, may at any time be revoked or annulled if the court decides, either on application by an interested party or of its own motion, that the proceedings to obtain the grant were defective in substance, that the grant was obtained fraudulently by the making of a false statement or by the concealment from the court of something material to the case, that the grant was obtained by means of untrue allegation of a fact essential in point of law to justify the grant, notwithstanding that the allegation was made in ignorance or inadvertently. D, that the person to whom the grant was made has failed, after due notice and without reasonable cause, either to apply for confirmation of the grant within 1 year from the date thereof, or such longer period as the court order or allow. 2, to proceed diligently with the administration of the estate, or to produce to court within the time prescribed any such inventory or account of administration as required by the provisions of paragraph E and G of section 83, or has produced any such inventory or account which is false in any material particular, or that the grant has become useless and inoperative through subsequent circumstances. So those are the grounds for revocation or annulment of grant. So that when we come to evaluate Amina's yes, Mr. Arnold.
Okay, banks umekuja kupitia this revocation and annulment of that. This part A, proceedings to obtain the grant were defective in substance. Kindly. Najua iko related to the question, but naweza taka okay. Na as in kuna venye inanichanganya, unaweza ni fafanulia yenyewe kidogo.
Now, if they are defective, the proceedings, we can say they are defective in the sense that kuna ile consent form that is supposed to be signed, but it is not signed, or the signatures were. Okay, ukiweka fraud unaingia part B. Let's say they don't have signatures attached to it. We are not about fraudulent activities. Ni defective by the fact that it has not been signed. Will that now make you revoke that grant? And the answer is yes, because it requires you to do the same. No. So it is defectiveness in proceedings. What are the timelines? Did you apply for confirmation before the lapse of the 60 days? Remember the court, we were told it has the discretion. If you make an application, let's say you are the sole beneficiary, and there is a consent from the others that we can just confirm within before the lapse of 60 days. So let's say ameficha vitu, alikuwa afanye notice of objection that was not properly conducted, alafu inaonekana kuna foul play even on how the documents are structured. Some forms are missing. We have a child, but we have one administrator. Remember, there is a continuing trust that requires you to have 2 administrators where a child is involved. So now there is defectiveness in the documentation itself and how the proceeding was conducted without going to fraudulent activities, because if it is fraudulent, then we go to part B, because I did a revocation of one where the client was kulikuwa na affidavit that was purportedly to be signed jointly by him and another administrator. So my client is telling me, I never wanted to be an administrator in this thing, and yet they are filing an affidavit that I signed acknowledging that I'll be an administrator. So hii kitu ilifanywa bila yeye kujua, secretly, hataki kujihusisha, and the reason is there is a curse that was left on that parcel of land, so this guy can engage into an accident. So he's very anaogopa sana, juu anasema sasa hizi ni curse zimeanza kumkula because wanaitumia jina yake as a sacrificial lamb, unaona. So ukisikia client kama huyo, your role is to take instructions nini under the firm nini, but sasa the ladies used fraudulent means to confirm the grant. So that was the first instruction, can you revoke this grant? And as much as I don't want to be so, the grant imepeanwa on grounds that mimi niko pale na so wameconceal, I don't want that. Alafu pia na challenge nini mambo ya beneficiary, mtu alifixiwa bila kujua, so such things. Fraudulent inatokea pia fraudulently on its own.
Jurisdiction inaweza cause nini kuwe defective.
Pecuniary jurisdiction.
Yeah, something like
Ni tricky. Unajua court iko na power to court. Okay, tuliambiwa kitu inapelekango high court. Revocations zinasikizango high court. Am I right? Can revocation be heard in the magistrate court?
No. Yes, as in like tumefanya niseme hivyo, sema wali obtain grant kwa nini kwa magistrate court. But as in the pecuniary or what inafaa kuwa wangeenda high court. So that inaweza cause nini hiyo grant iko defective ama hizo proceedings za kuobtain.
Hiyo ni moto. Tabu nisikize other members. People can nini your jurisdiction that granted you the naitwaje that grant na ulikuwa umeapproach magistrate court and yet the asset value should have gone to the high court. Should it really revoke that grant on grounds of jurisdiction? Should the court do that? Ama iko na power so moto to transfer the matter as if that is tricky. Mr. Chedik, yes?
I'm looking at owners of motor vessel. Jurisdiction is everything. Yeah. Without it, the court have to done it too. So if the court that issued it already lacked jurisdiction, then it has no capacity to even transfer it, because it will be acting on a point of no jurisdiction completely. So I think you should just approach the proper court and make the application.
Thank you. So hapo that I believe has been answered. So Mr. Arnold, we can now take that as one of the procedure. And remember I said something about watoto, a continuing trust, and I've found a provision, section 75A, that tells us otherwise, that if after confirmation of the grant or letters of administration, at any time there is a continuing trust and only one surviving administrator, that survivor shall, without delay, apply to the court to appoint, subject to section 66, as administrators jointly with him, not less than one or more than 3 persons as proposed by him, which failing as chosen by the court of its own motion. If a sole surviving administrator fails to apply to the court in accordance with this subsection 1, within 3 months of there being a continuing trust and only one surviving administrator, on the application of any interested party or a creditor or debtor of the estate or of its own motion, the court may appoint additional administrators in accordance with subsection 1. So there is a room where the surviving administrator will appoint another one person to section 66. Preference to be given to certain persons to administer where deceased died intestate, and one of the persons who will be given discretion is the public trustee. Okay, so he basically inapeana two preference to be given to certain persons. So we are saying that one of the persons to be given also priority ni a person with the court's permission mwenye amekuwa appointed by the surviving administrator under section 66 to even the public trustee, where the court can allocate you if you don't make a provision under section 66. So the proper thing is not to revoke that grant for you to add another administrator to hold the continuing trust on behalf of the minor's interest. You just make this application as we have been directed by section 75A, and guided by section 66 on preference, and if you don't do that, the public trustee will be appointed by the court, and even creditors can also do so. Can also apply for the administrator to be appointed. So basically hapo tumeclarify, tunaenda to clarify vitu. Now we have also clarified Mr. Arnold's point. Now what is the marking scheme really saying? Should Amina now draft hizo grounds of objection, or should Amina now only focus on reasonable provision? And if it is reasonable provision, I've also shared a video of 37 minutes telling you how exactly you will draft the reasonable provision application. So that now we go to the marking scheme and evaluate Amina's claim. We see what were the marking points. We will go direct. Amina's claim to her father's estate, 5 marks. So Amina may challenge her exclusion on 2 alternative grounds. Testamentary incapacity arising from an insane delusion. Although Kwaheri was generally capable of making a will, testamentary capacity may be undermined by an insane delusion that directly influences the disposition. The mistaken hospital incident appears to have generated a fixed and irrational belief that Amina intended to kill him. The evidence indicates that Amina was assisting her mother in caring for him. She merely attempted to turn him into a comfortable position. He awoke and mistakenly believed that she was strangling him. He thereafter remained paranoid and suspicious of her, and that belief apparently caused her exclusion. Amina should argue that the belief had no rational factual basis, persisted despite reality, and poisoned Kwaheri's judgment concerning her. Under the Banks versus Goodfellow test, a will is invalid to the extent that its disposition was produced by a disorder of the mind or delusion concerning a person who might reasonably expect to benefit. The important distinction is that an ordinary mistake, dislike, or unreasonable suspicion does not necessarily amount to an insane delusion. Amina must prove that Kwaheri's belief was fixed, irrational, and causally connected to her exclusion. Medical records and testimony from family members, nursing home personnel, and their testing witnesses will be relevant. If proved, the gift scheme may be set aside to the extent affected by the delusion. Depending on whether the affected provision can be severed, Amina's share may be devolved through partial intestacy. Now, the examiner is also expecting to hear about application for reasonable provision. Even if the will remains valid, Amina is Kwaheri's daughter and therefore a dependent under Section 29A of the Law of Succession Act, whether or not he maintained her immediately before his death. Under Section 26, where a will fails to make reasonable provision for a dependent, the court may order reasonable provision out of the net estate. Under Section 28, the court considers matters including the nature and amount of the estate, Amina's present and future needs, gifts made to her during Kwaheri's lifetime, the circumstances and needs of other dependents, her relationship with the father, the deceased reasons for excluding her, and her conduct towards him. Amina should file her application before confirmation of the grant as contemplated by Section 30. Okay, you see that provision? You do this application for reasonable provision before confirmation of grant. The court will assess reasonable provision rather than necessary award an equal share. So what is the conclusion that the examiner wanted? Is that Amina has an arguable capacity challenge because her exclusion appears to have resulted from a persistent delusion that she attempted to kill Kwaheri. And we have relied on Good versus Bankfellow. That is the marking point that the examiner will be looking at. If she cannot prove testamentary incapacity or delusion, she may still seek reasonable provision as a child and dependent under Section 26, 28, and 29. So she has 2 options: through challenging the will, and if she cannot prove testamentary incapacity, you go to court using reasonable provision under Section 26 and 29, where you have been omitted from a valid will. So I believe that will grant you the 5 marks. So the mistake that the student could have done is to omit the second option that Amina had, because if you go direct to application under reasonable provision, you could have ended scoring up 3 marks, because the other one is a brief and direct to the point. So after his death, it later emerged that on 20th February 2024, Kwaheri had acquired some 20 acres of land which he had intended to donate to Mji wa Furaha Children's Home. As a result, he left it out of the list of his property which was distributed through the will. However, owing to his failing health, he failed to follow through with the intended donation, and by the time of his death, the same had not been passed to the children's home. Distinguish the process of administration of this piece of land vis-a-vis the rest of Kwaheri's estate. So exactly how will the process of administration of this piece of land that was left out be conducted vis-a-vis the rest of his estate? Any member? How do you deal with such properties? 5 marks. I've seen from the timeline we have 7 minutes left, so that we will also have to deal with further discussions of the question paper in the evening, and remember we still have conversing left pending, so we must finish up on those papers. Then we jump to other units or other series. I'm currently doing 2023. So what is the process of administration of a piece of land that was to be transferred to Furaha Children's Home, but he never followed through to make sure that his intention went through, okay? And vis-a-vis the rest of Kwaheri's estate that has been administered through the will, because this was forgotten. How will you go about it? What is the examiner looking at? CLE walisema another factor that is making students to fail is to give stories rather than going straight to the point of what you have been asked to do. So in this situation, will you give stories or will you go direct? I have left out a property. How will you go about it? And this part is very important because it is showing a certain disconnect. Is it that the students are not understanding, or is it that the examiner is ambiguous, or is it that students have only one way of looking at issues? They have only been taught about properties falling inside a will or intestacy, but they have not been told about a situation where somebody has forgotten a property. Is it that CLE is testing a real problematic situations that will actually face you on your feet? That when somebody is drafting a will or there is intestacy applications, now a person can forget a property. Where is this part to be covered in the law of succession? And how hizi situation ni ngapi zenye unaweza overthink for you to be in the bracket of knowledgeable students? To what extent can CLE go in asking untaught, in brackets, in quotes, untaught scenarios? Where do they get these scenarios from? We were told by a person setter that CLE gonna 5 drafts of examinations. Then they choose the one that they will test. So in choosing that this is the one that will test, what informs them? What is the marking the examiner testing? Will it test that there is a batch of students who will now do a rectification because they don't know that you can't use rectification to include new properties? Rectification is only reserved to clerical errors, names, nini. Will you do a revocation? Now, even if it is revocation, hapa tunaambiwa it was donated. He had intended to donate. Do you know about gifts in contemplation of death, gift inter vivos, Okay, there is proof of delivery of possession to what extent, because at the time of his death, the same had not passed to the children's home. What happens? Are you taking that route? Okay. So, with the consensus of you, that is when I will look at the marking scheme. But if you don't give me the content, I will still have to hear from you to see whether you are reasoning it out. Yes, Mr. Chadwick.
Okay, let me also try not to give stories the way Celia said, but I'm looking at it from the point of the first point is the issue of the testamentary freedom, where a deceased is at liberty to dispose his will as he wishes, but this gift had not yet passed by the time he had died, and we look it from the point of I'd call it the armchair rule, something like that, where the court look at the intention of the deceased prior to his death. But now, looking at it, it had not yet passed to them. So, when making the process of administration, or like when applying, I think we'll apply that since the deceased had intended the donation to go to the children's home, it should be excluded from the estates of the deceased. I think that's had reason up along that line.
Thank you. That is well captured. And you remember that I'm limiting. In my view, this question was performed poorly because it is a bit technical, because it is distinguishing two procedures and putting a student on his feet. Now, let us see what the examiner wanted. Then we close the session and now wait for the evening one, because of late evening zangu zimekuwa held up. That's why I know I have two gaps. Remember, we also postponed one session, so we must recover the same. Administration of the 20 acres compared with the rest of the estate. So the intended donation was incomplete, as Mr. Chadwick tells us. An intention to donate property does not by itself transfer title. Since Kwaheri did not execute and register a transfer or otherwise complete the gift to Mji wa Furaha Children's Home, the 20-acre remained his property at death. The Children's Home cannot ordinarily compel the estate to perfect an incomplete lifetime gift because Kwaheri intended to make it. Equity generally does not perfect an imperfect gift. 2. The land was not disposed of by the will. The will distributed the assets expressly listed but omitted the 20 acres. Unless the will contains a residuary clause broad enough to cover all property not specifically listed, the land is undisposed of by the will. So Kwaheri therefore died partially tested and partially intestate. The assets disposed of by the will devolved by testamentary succession, and the 20 acres devolved under intestate succession. So difference in the grants will be that under Section 53 of the Law of Succession Act, the will-covered estate is administered through a grant of probate if an executor was appointed and is willing and competent to act. If there is no executor able and willing to act, a grant of letters of invitation with the will annexed may issue, and the undisposed 20 acres require administration of the intestate portion. Where one estate is partially tested and partially intestate, the court may structure the grant to cover both aspects, both but the administrator must identify them separately in the petition, inventory, and proposed distribution. So the 20 acres should not be distributed according to specific gifts in the will unless a residuary clause captures them. Okay, so distribution of the 20 acres. The land must first meet its proportionate share of funeral expenses, administration expenses, debts and liabilities, and any court-ordered provision for dependents. The balance is then distributed under the applicable intestacy provisions. Because Kwaheri had more than one wife, Section 40 is likely relevant. The intestate property is divided among the houses according to the number of children in each house, adding each surviving wife as an additional unit, and then distributed within each house under Section 35 to 38 as applicable. James, John, and Amina cannot be excluded from the intestate 20 acres merely because they were omitted from the will. Their rights in that property arise under intestacy unless they validly renounce them or are otherwise disqualified by the law. Mere disrespect or an unfounded suspicion does not disqualify a child from succession. 5. Rest of the estate. The rest of Kwaheri's property should be administered according to the valid terms of the will, including Jane's original bequest if the attempted alterations and revocation are held ineffective. It remains subject to payment of debts and administration expenses, proof and confirmation of the grant, and any successful application for reasonable provision under Section 26. So the conclusion is that the intended but incomplete donation leaves the 20 acres within Kwaheri's estate. Unless covered by a residuary clause, it constitutes the intestate portion and must be distributed under the statutory intestacy rules, where the property effectively disposed of by the will is distributed according to its terms. So what did the examiner clearly want from a student? He wanted you to know that first, the donation was incomplete. And if you know that, then the gift inter vivos, okay, during lifetime did not materially pass. So there was no transfer or actual passing of ownership. So that is one mark. Then you will be told the examiner, we also wanted you to say, to identify whether this parcel was disposed of by the will. And the answer is no, it is still not listed in the will. So the examiner now tells you, do you know the difference between a grant of probate where there is an executor, a grant of letters of administration with the will annexed if there is no executor that was appointed? That is under Section 53 of the Law Succession Act. Now, we have a situation where there is a will, there is no executor, so with the will annexed. Then we have the 20 acres that is not under the probate route, but not the will route, but it is under the intestacy. So do you know that a person's estate can be governed by two regimes? You can go at one hand using the will and at the same time going through intestacy. Okay, then do you know that at times, if the will had indicated about a residuary clause that states the left out or omitted properties arising from my name and have not captured in the will, they will go to a class of beneficiaries. Let's say a class of beneficiaries to say children, my nini sons, nini Ivo, that will have made the 20 acres to be subject to the will. But because the fact sheet was silent, there is no residuary clause. This is the reason why we are administering the 20 acres under intestacy. Now, many students will still not guide the examiner on exactly how this distribution of the 20 acres will be governed. And do you know the priority that is should first be met on payment of funeral expenses, administration, debts and liabilities? Then if there is any court ordered provision for dependents, then it is the balance, it is the net balance after all this priority has been considered, all these priorities, then the balance will now be distributed under applicable intestacy provisions. Okay, because there is more than one wife. So it is among the houses according to the number of children in each house being counted as units. So do you know that James and John still cannot be excluded from the intestate 20 acres merely because they were omitted from the will? and how will the rest of the estate be administered. Okay, then what is the conclusion that you're giving the examiner? So one thing that I'll tell you is whenever CLE imekupea 5 marks, remember CLE is also mean with marks. Never take an assumption that you know the ordinary answer, but you are omitting to state the ordinary answer, because no one expected the examiner to go to that extent. Exactly how will you narrate and ikuwe ni marking points that you are guiding the examiner to look at. Unaona? So that is my emphasis, because where CLE says 2 marks, we have also seen the direct answer to the 2 marks na kila mtu anaonanga iko very sufficient. Where it is 5 marks, kila mtu anasemanga yenyewe, because even the factual matrix iko well loaded to give you the 5 marks. So let us be keen on 5 marks, 10 marks questions and avoid summaries. So maybe from this end, I wish to end the recording because of time. We have now met the threshold of time. Now let me address the preliminaries. There is an observation that we have not done trial advocacy, LPM and LWD sufficiently. So we have said that these questions are repetitive, and we will go to the extent of now purchasing separately for those papers. I'll purchase those papers, then I will perfect that marking scheme, because the marking scheme that I bought one paper from that person, lakini inakaa ametumia AI, alafu hata kama ni AI, ni ile AI inaweza hallucinate. So we don't want such kind of answers to be projected, and pia because of copyright issues. So I've directly told you that today I intend to purchase one for LWD, and the reason is LWD maswali ni zile zile. If it is a bill, if it is an amendment, ni ile ile tu imeishi kuulizwa. Unaona, kama ni trial advocacy ni the same advocacy style. Kama ni LPM ni the same way of managing a law firm. Kama ni accounting questions from LPM ni the same accounting questions all the way from 208 all the way to 2019 etc. So let me arrange myself, because each paper is going for 500. Let me purchase them. Alafu because I have an intention of also copywriting mine, I'll now modify, because the laws of copyright allows you to modify something, then you make it perfect, then you can sell it. So let me do that, because itakuwa imetusavia time, alafu you will not have now to worry that you have not conducted adequate research on those units. So now, Mr. Martin, I'll give you the mandate of being the prefect of the 3 units. So you will be the prefect of LWD, LPM and trial advocacy. Your role is to push that we also capture those units in our timeline. So make sure that ukiona ni kama tuna veer off, natumbia hey look, today we can do this paper nini, so we give it adequate consideration, because that we have already cemented our position. I'll use more time when it comes to the quote in quotes the hardest units, because pressure ya hizi hardest units ikikupata last minute akunanga comeback. It's either you are well grounded or you know nothing. So the other unit yenye pia ni dangerous, criminal litigation. Kumbuka criminal litigation pia iko on the radar. It is one of the failed units. So let us purpose also to do many criminal litigation papers. I'll also give it a lot of priority. Professional ethics, at least hapo tumeshika line. Convincing tumeanza kushika line. Probate tumeanza kushika line, so that is the best thing. Commercial transaction tumeshika line, sasa ile tunaweza sema hata tuko almost 60%, and it is very dangerous to also go to 80, na yet kuna another unit yenye uko below 20%. So let us do those kind of valuations. So we can also have a list, kwanza nitume zenye so far tumemanage kufanya, so that we identify from this list this is what is missing. So let me do that work over the weekend, and niwaambie this is what we have managed, this is not what we have managed, what can we do about this, what about can we do about this trial advocacy hivyo, so that we have a checker system where we balance off everything, Mr. Martin, and that is a very good observation. So Mr. Arnold, pia welcome for joining. Unless you have closing statements, mimi nitafunga session.
Thank you very much.
Sawa sir. Thank you. So let me end the session. So let us do a recap of what we have done over the weekend. We count as milestone 1, then come with various solutions for going forward. Sawa, thank you.